Example that Senator Chambers gave, and there are many others like it, like the Lauder case, where two people equally culpable, one person is on death row and one is not. That is fundamentally unfair. We cannot have that in Nebraska.
1 minute.
And I think Senator Lathrop made a very, very good point, and that is this is a new way. And to the, maybe it was Senator Erdman or Senator Friend, and they've given good comments, but there is nothing wrong with having a new way. There's nothing wrong with looking at another way to deal with this problem. It's a new way. Senator Lathrop is absolutely correct, and it hasn't been tested. The language that we proposed has not explicitly been tested, but we do that all the time here. So I'm trying to find a good reason to change my mind. I can't find one. There is not a good reason to continue, not one reason at all, to continue the system as it is, under any circumstances. And that is our job and the job of the Judiciary Committee, to bring to you what we think is the best language. Is it perfect, as Senator Chambers suggests? There is no perfect language or perfect result. But it is an advancement. It is a narrowing. But when you are talking about the death penalty, a narrowing is not an inappropriate response. Thank you.
Thank you.
This law, however, will focus us that those on death penalty from here forward will share one characteristic and one characteristic only. They are too dangerous to be left alive. We will not compare their victims. We will not compare how horrible they behave.
Senator McGill's time has expired, but you're next in the queue to speak.
Those things that cannot be compared anymore. We will simply make, to the best of our ability, a reasoned judgment going forward. Senator Flood asked a very, very good question. He said, what is the state required to prove, and how can they possibly prove it? Let me give you a broad example of people that I believe, without question, will continue to face the death penalty, and properly and morally so. I have given you an example of the gentleman who faces trial for the murder of Amber Harris. Should that gentleman be convicted because of his history of escape? I have no doubt, as a trial lawyer, that he can and likely could be sentenced to death because of that. Others, inmates who kill in prison, inmates who kill guards, no question in my mind, given the fact they were incarcerated, given the fact they took life, will certainly face the likelihood of being sentenced to death. Others. The Aryan Nation is a most insidious criminal organization. Its roots and its strength is based in the penal system. It recruits, it disciplines, it trains, it educates, it operates largely out of the penal system in California. It is reputed to regularly order executions through membership, both among those in the inmate population and those outside. It runs drug rings. It runs murder for hire. People associated with that who commit crimes can reasonably be concluded to have the capacity to threaten innocent life both inside and outside of the prison system, and they can be, in my mind, justly and morally executed, and deservedly so. Similarly, terrorist organizations. I have no question that such are the case. People who are serial killers. A jury could reasonably conclude that they are so driven to kill that they remain a real risk despite our ability to incarcerate, because they operate from a compulsion that cannot be controlled. I want also to point out that our capacity to incarcerate, while fairly considered in this, does not eliminate the need or the use for the death penalty. There have been instances of prisoners held at the highest levels of security in both state and federal institutions that have attempted to murder guards. Given that situation, should they succeed, again, without question, they can be executed and should be executed. those who plot and would plan and try to commit mass murder, whether that is in our schools, whether that is through poison gas, through other methods, can reasonably be concluded that they are doing it from an ideological basis and will continue to act in the future. They surely can and should face the possibility of a death penalty. Now, I'd also like to address the issue of procedure versus substance, and how do we know the difference. Senator Erdman, I would suggest to you the following as just a guideline. When a jury determines it, it has to be substance. Juries never determine procedural issues. They determine factual questions, and the United States Supreme Court has clearly indicated a jury must determine issues like this. Given that fact, I would say to you that this penalty, along with our language, virtually assures that it will be only applied proactively as it is intended. I think, therefore, the argument that this in some way overturns existing sentences is not well-founded, and indeed is done only to try to derail what is a good faith effort to bring rationality and indeed long-term viability to the death penalty. And the fact that I may be lending whatever skills I have to ensuring the execution of people in the future is nothing if not a heavy burden for me. And I urge the members to seriously consider the weight of what we are trying to do here, because I submit to you, we are actually probably prolonging the death penalty by this measure. Thank you.
Senator Peterson.
Thank you, Mr. President. Members of the legislature, this morning I passed out this piece of paper to you people. Look at it. It's a very important piece of information that every senator should look at, that comes from the Department of Corrections on almost a monthly basis. It tells you what our population is in every one of our facilities, what it costs to keep an inmate in each one of them facilities, telephone numbers, the types of crimes, and so forth. On the bottom of the second page, on the back, on the left side, you'll see life sentences, May 21st, 2007. Total inmates sentenced to capital punishment, 10. Total inmates serving first-degree life sentences, same types of crime, 211. Out of this 211, there's a lot of them who have committed a lot more heinous crimes than we have in the 10. Prior to me coming into the legislature, one day I was asked to accompany a friend who was a police officer to a murder scene because how startled and feared he was of just the scene. It was a young lady who had been raped multiple times and murdered. Being a mortician many years ago, I have seen many death scenes, but I had never seen the terror on the face of a body that was like on that young lady. That man I know today, he's doing life sentence. Death penalty was not even considered. He's doing time in the state of Nebraska. If I can't appeal to anything else, can I appeal to your fairness of the way we distribute this death penalty? It has not been given out fair, either racially, poor people, and yet if you've got the defense and the money for defense, those people have come out in much better situations. There are also lots of cases where they came out even a lot better and they didn't even get a life sentence. They're on the streets. and yet we say we are fair, consistent people. I don't condone killing somebody. I would do anything in my power to defend somebody from getting killed. Same thing I'm doing here. If you got fish in the barrel, why do you have to shoot them? They're not going anywhere. They're not doing anything. And we aren't getting anything of it but revenge. They're still killing people in Texas, people. Murder is very high in that state. And their value for life down there is not much because they kill a lot of them in their capital punishment. Is it helping? No. And I'm not even concerned at this point about deterrent. I'm concerned about fair and consistent. And we have proof right here on this piece of paper that that isn't being done. If all you want is revenge, you will never get it. You will just have a burning heart. Fairness is one thing. With this amendment, we're making sure that those who would kill from inside could still be put to death by the state. Let's not condone it any further than that. Thank you.
The most heinous crimes were committed by those who are sentenced to life in prison today. That's the analysis that were given by Senator Peterson, and as far as I know, he's probably right. He has more experience. He deals with the inmate population of our state probably more so than any of us. And to have him make an analysis of the individuals that are currently sentenced in the state to our institutions, I find no fault with that, and I'll take his on it. The consideration that I also balance that with is that an individual in the state of Nebraska in the future goes into a bank building and guns down a number of people, and now, as we have heard in the past, we're going to contain them for life, and there's no concern that they're going to get out. They're not now eligible unless they're proven under the new scheme to meet the new definition of who's eligible for a death penalty or for the sentence of death to be carried out. However, you have somebody who's in prison for a lesser offense, and we actually have someone who is there, and I don't know all the details, but it was actually a murder charge that put them in prison in other states as well as Nebraska. But they commit one murder on a prison inmate, and all of a sudden they're eligible for the death penalty. And I really am struggling with this. I want to understand how that's the worst of the worst. I think it meets the definition of we can't contain that or ensure that that individual is not a threat to someone else. I think that threshold is there. But if we keep coming back to the idea that we have to give this to the worst of the worst, we still haven't obtained that goal. We know, and I would encourage you to do this if you haven't. Before I began to carry any legislation or look into this area of law, I studied what we did in Ring. I read the transcripts of that special session hearing. I haven't read it completely through, but I've read the transcript on LB377. You're going to learn a lot from the perspectives as to how we should proceed. We cannot, and this is from Senator Chambers, this is a reflection of the United States Supreme Court, we cannot sentence or set a mandatory death sentence. We do not have that right. And I hope that I'm reading that correctly. The case that the Supreme Court time and time again has made that observation. But we keep coming back to the idea that we have 10 cases, 10 different outcomes. Somehow we want to predetermine those. My question to Senator Ashford this morning wasn't whether or not the court would hear their case and overturn it, but whether or not what we're doing leads us down the path of retroactivity. I don't believe I ever asked Senator Ashford whether or not the court would overturn their sentence. I'm simply trying to understand this process now that we have changed the standard. But I am extremely interested, again, where I begin this afternoon with the discussion of what happened over the lunch hour. And I'm informed that Senator Lathrop is going to share some of those perspectives. At this point, I think this language is an impossibility to obtain a conviction, and I think Senator Lathrop has some insight that may help me and better understand this, and I look forward to that. Thank you, Mr. President.
Mr. President and colleagues, thank you very much. Senator Ashford, thank you for bringing this forward again. Quite frankly, I don't think we can say that this legislature has ducked any tough issues this year, because we've definitely taken them on. I really rise to oppose both 912 and 377. And when I look at the bill and the amendment, one thing they talk about in the amendment is the execution is revenge. It's not revenge, it's justice. And the other issues that I read in the actual bill itself, it talks about all these errors, all about these frustrations, all about these delays, constitutional mistakes in the statutes, defective legal procedures, implementation of the statute, lack of uniformity in application. That's what's wrong. Why are we not talking about those issues? Because that is the issue. Since 1978, folks, this body has been aware of these. And I've gone back and historically looked, and I can't find many places where this has been discussed. If we're going to talk about these issues, let's clean up the system first. And then, you know what? I don't mind talking about the death penalty. I don't mind dealing with these issues. If this is what it's about, then it's wrong. You know, I told you when we talked about the repeal, when I look at the Raymond Ramada case and the Jeffrey Hessler case, I can't go home and do that. I can't look at these people. When we're saying right in our own law that we have all these mistakes and all these errors, and I'm going to say to these people, because you know what? We don't have the ability to correct our justice system. We don't have the ability to make these adjustments. I can't do that. Can you do that? Can you look at these people? And can you look in their eyes and see the fear and the sadness? I can't. And what I'm saying to you, that's what we ought to be fixing today. That's what we ought to be dealing with today. And then I don't mind coming back and debating whether we should or we shouldn't. But if this is what's causing it, then that's what we ought to fix. And I oppose where we are today because of those issues. Until we're willing to fix this, until we're willing to correct these issues and make this judicial system the best we can possibly make, I will battle this and I will fight this until we finally correct it. Because that's what we're arguing about here. That's what I heard my friend Senator Ashford say. Those are the issues. Why are we not addressing these? Why are we not fixing these? And that's what I pose to you as a legislative body. That's the issue. Thank you very much, Mr. President.
I want to talk a little bit about the judicial branch of government, talk about trials a little bit. I think that, as you know, I've been a practicing trial lawyer for now almost 26 years. I've had the privilege, truly the privilege, to try cases in state and federal courts here in Nebraska and Iowa, even Missouri. And I think people have this notion because we have the best judicial system in the world, the pillar of which is a jury trial, that somehow our system of justice comes to the right conclusion in every instance, that it works perfectly, and that at the end of every trial, perfect justice has been done. And I have to tell you, after having tried an awful lot of cases, that if I tried any particular case 10 times, I'd probably come up with 10 different results. And that should tell you something about our system. As good as it is, as perfect as we try to make it, it is the work of mortals working at something that we think is justice, some notion of justice, and we have in place all the safeguards for justice, and sometimes it doesn't happen. We have, across the country, 123 people that have been put to death that have been later exonerated. Senator Harms earlier spoke and suggested that we shouldn't be involved in a discussion about the death penalty or some limitation on the death penalty. We should be involved in a discussion in fixing the system. Senator Harms, and for the rest of you who share Senator Harms' point of view, this is as good as it gets. We have human beings that sit in judgment. We have juries that come into the courthouse with their own points of view, their own biases, their own predisposition to see things in one particular way. That is our system. It is not perfect, and so there is nothing left. Our Supreme Court has done a good job. Our legislature has done a good job. We've made this system as good as it can get for human beings to administer, but it's not perfect. And now the question today is whether we are going to argue about the fact that our human system is imperfect or whether we're going to do something about it. We have, as a measure, a confounded list of aggravators and mitigators, and that system is made more complicated by prosecutorial discretion and immunities that are granted. All we're asking for in this bill and in this amendment is that we use a rational basis for determining who should be put to death and who shouldn't. Thank you.
We don't know what this is going to do. What are our prosecutors going to do with it? How are our judges going to interpret it? I think those are legitimate questions. They're practical questions. We need to have them answered. Philosophically, we'll all deal with those on our own, off to the side. But I think the philosophical arguments are irrelevant here. I think the practical arguments are. Thank you, Mr. President.
It's also my understanding that in the event that there is no explicit or implied or direct opportunity for an individual to be given that right, when we as a legislature choose to reduce a sentence, they'll still have that opportunity. Now, we can't raise the sentence. If we sentence somebody for 20 years for something, we can't arbitrarily come back and go, no, it's now 30, and everybody that's been sentenced for 20 is now at 30. We can't do that. But it's my understanding that in the event that we do reduce a sentence, that those individuals will have a right to make their case. This is an appeal. And I'm willing to be corrected. But in visiting with individuals that litigate and that try cases under these existing provisions of law and understand the greater breadth of the court and the entirety of their deliberations, I believe that's accurate. So whether you intend it to be retroactive or not, retroactive in the sense that everyone gets commuted by the passage of this bill, no. But retroactive in the sense that I believe that you give an opportunity for individuals currently sentenced to be able to make the case in court that this is a reduction in the sentence and they don't fit under this new definition as other individuals have challenged it successfully before the court. Those are the practical types of discussion. I appreciate the 35,000-foot view of this discussion that we had on LB377. This is not a touch and go when we go back to 35,000 and say, no, that's not what this is, trust us. We need to land the plane, and we need to examine it. That's the practical application that I believe needs to be undertaken here.
Erdman had pointed out that Senator Chambers did us, I guess a one-up by providing an amendment that allowed bloviating blowhards like myself and others to actually continue talking without trying to get too creative about it as to what you'd need to throw up on the board. Over the lunch hour, Senator Flood summed it up fairly well, but he didn't totally capture it for me. Go back to my office, and I'm usually, I guess maybe can be considered a cheeky or jovial person, I hope. Sometimes you just feel empty. And over the lunch hour, I said, I got to go get some, gas from my car, and I just sat in my car. I didn't read anything. I didn't listen to the radio. I just sat and thought about this debate. And sometimes I may come off a little bit insincere, but I'm sincere about this. I don't think anybody's having a fun time here. I think Senator Flood pointed that out, and I would totally concur. I have a lot of fun out here with you guys. This doesn't qualify. Senator Lathrop mentioned, and I mentioned earlier, though, that I'm glad I'm here. I'm glad we're working on this, because I, quite frankly, can think of, and this is going to sound like I'm patting you all on the back, I can't think of a whole lot of people that I'd rather be working with at all. Senator Lathrop had mentioned earlier that he's looking for a rational basis. We're all looking for a rational basis in regard to the distribution of the ultimate penalty that we have. I would submit to you that, and I did it earlier, that individuals based on this language are still going to be making those decisions. Does this law make those decisions any more arbitrary or less arbitrary? I think that an argument can be made, and logic would dictate, that there would be less arbitrary behavior, judicial behavior. The route we're taking here, however, prevents us from eliminating it. I don't mean to be redundant about that. I know that I said that before, but it prevents us from eliminating the arbitrary behavior. The arbitrary nature of decision-making by human beings was removed by Senator Chambers' original bill. It's not here. The language in this bill requires the finders of fact to speculate on the potential future behavior of an individual. Other states have done this with different language that I mentioned earlier, 3 other states. But the language is important. And if our standard that we're setting here, the language that we establish is different, or to me, it's going to be difficult to quantify. Senator White gave examples earlier of the terrorist behavior and crime lords and folks like that as potential individuals that this type of legislation would target. If these individuals are targeted as prospective candidates for the fair and equitable usage of capital punishment,
1 minute, then juries or judicial panels are going to be making those arbitrary decisions. That's simply just the fact of the matter. What happens if a terrorist, gets into prison and says, you know what, for whatever reason, I found religion, I won't hurt anybody ever again. Somebody's got to make an arbitrary decision about that particular guy. He's killed hundreds of people. That's the hypothetical. We're heading down a strange path here, folks. That's all I'm saying. The stuff we were dealing with 2 weeks ago wasn't that strange. Tough, but not strange. This, to me, is a little bit strange. That's all I'm trying to decipher here. And I want to continue listening to the discussion. I know these things are going to I know these things. Time, Senator.
Thank you, Mr. President. Whether or not it's constitutional, it may be. It's a rhetorical question I'm throwing out there. To expose a particular person, a terrorist.
I want to emphasize that if indeed this amendment effectively repeals the death penalty, that's a bad thing, to put it simple, for the reasons I elucidated earlier. Folks in prison at this stage are not isolated from the public. That's not the case. And it has been shown that individuals can effect destruction from the cell. We have a responsibility to disallow that. And so I'll pay close attention to the pragmatic realities of AM 912 and how it plays out jurisprudently.
Time.
Thank you. A mob boss, gangster, whatever. I mean, somebody who is striking fear into society, to expose that particular person to increased punishment based on what the finders of fact believe that he may do. Senator Cruz had pointed out earlier, and it may have been in reference to me, that we've tossed out the term arbitrary quite a bit here about arbitrary judicial behavior. I'm concerned about arbitrary judicial behavior. I do assume that we have arbitrary judicial behavior right now. And I always point to Senator Aguilar because he has brought out almost virtually a fact that there is arbitrary judicial behavior right now, based on some of the examples that he gave earlier. Not just on this bill, but the previous bill, 476. While this bill may not exacerbate that arbitrary judicial behavior, it doesn't repair it. It does not fix it. This language doesn't ease my concern, members of the legislature. It just doesn't. And I truly do appreciate this debate. I'm not going to say much more on this. I appreciate Senator Loudon yielding his time. I don't know if I get the feeling that people want to move on now or not, and I guess we'll find out. I just finally wanted to let you know how I felt about it. And thanks for hearing me out. Thank you, Mr. President.
Senator Friend said it best for me when he said, I do not answer to the Republican Party. I do not answer to the Catholic Church, which I'm a member of both. I choose to be members of both of them because they have, for me, what I want. 377, I believe, is the right thing to do. If it was complete repeal of the death penalty, you know I'd vote for that too. I think killing by the state is wrong. Senator Chambers mentioned a prisoner. His name is Kerry Dean Moore, who the state will probably be killing next month at his request. But how many people in here are against state-assisted suicides? That's what we'll be doing in his case, because he's choosing to die. And the main reason he is, and I know this man personally, is because he does not like what's happened to him in the system. Death is a better thing for him than prison. I had a constituent the other day said to me, an old friend who's very pro-death penalty, questioned me about my beliefs, and when I told him about some of the inequities or the unfairness of the death penalties, minorities, and some that have been exonerated because of DNA, showing us fact that we've probably killed people who did not commit the crime, he said, well, that'll happen once in a while. Send them up to God and let him sort that out. Are we of that frame of mind? I know all of you. I don't know all of you real personally, but I know most of you personally. And can't believe that what we hear and what we read is not true. If we're killing only because of that's what our constituents want, then why are we not educating them more on what the death penalty really does and what it is? I cannot and will not support state killing, but I did support Amendment 912 because it is better than what we have. And I think it would be fair for those people who are in favor of the death penalty. Please search your minds and hearts to do what is right here, not just what is political. Thank you.